The federal tax stamp required for applications to buy gun suppressors is now free.
It has been almost a century since the federal government put strict limits on gun suppressors.
Well, according to the IRS, the law significantly affects federal taxes, credits, and deductions.
Well, a nationwide change beginning today for people who purchase suppressors for firearms.
Some changes have been made to the massive tax, including ones that would loosen regulations on gun suppressors.
But we passed the largest tax cuts in American history. We delivered 100% expensing. That's a big one.
For 92 years, the federal government has kept a registry of every legally owned suppressor and short-barreled rifle in America. The entire system was built on one thing: a $200 tax. That tax no longer exists. Congress deleted it, but the registry it justified is still running. And this week, gun rights lawyers filed the paperwork designed to bring the whole thing down. On July 14th, 2026, the Second Amendment Foundation and its partners filed supplemental briefs in 3 separate federal lawsuits. 3 different courts, 3 different states, 1 target. The National Firearms Act's registration requirement for suppressors and short-barreled rifles. The filings argue that 3 Supreme Court rulings handed down in just the past 4 weeks have kicked out the last legal leg the law was standing on. If even one of these cases wins, more than 5 million registered suppressors come off a federal database, the 9 to 12-month ATF wait time disappears, and one of the oldest gun control laws in American history loses 2 of its biggest categories. But to understand why lawyers think this is finally possible after 9 decades of failed challenges, you have to understand the legal trick the law was built on in the first place. Back in 1934, Congress wanted to restrict access to suppressors, short-barreled rifles, short-barreled shotguns, and a handful of other weapon types. But Congress doesn't have unlimited power to ban things outright. It has to point to a specific constitutional authority for every law it passes. So instead of banning these items directly, lawmakers used the power to tax. Anyone who wanted a suppressor or a short-barreled rifle had to register it and pay a $200 tax. Courts upheld the law for decades on exactly that basis. Not as a restriction on a constitutional right, but as a tax, which Congress is broadly permitted to levy. That foundation held for 91 years. Then last year, Congress passed the sweeping tax and spending package known as the One Big Beautiful Bill. Tucked inside it was a provision that eliminated the $200 tax on suppressors and short-barreled rifles entirely, effective January 1, 2026. Gun owners cheered it as a win.
Well, according to the IRS, the law significantly affects federal taxes, credits, and deductions.
Some changes have been made to the massive tax, including ones that would loosen regulations on gun suppressors.
But we passed the largest tax cuts in American history. We delivered 100% expensing. That's a big one.
But gun rights lawyers immediately spotted something else. Congress had just knocked out the only constitutional justification the National Firearms Act's registry ever had, while leaving the registry itself completely intact. The tax that justified the law is gone. The paperwork, the background check, the months-long wait, and the federal registration entry are all still there. To put the scale of that registry in perspective, gun rights groups estimate Americans currently own more than 5 million legally registered suppressors, along with an unknown but sizable number of registered short-barreled rifles. Every one of those items still requires an approved ATF Form 4, a photograph, fingerprints, and entry into a federal database. The exact process that existed when the $200 tax was actually being collected. The only thing that changed on January 1st was the dollar amount. The bureaucracy stayed exactly the same size. That contradiction is now the subject of 3 separate lawsuits working their way through 3 different federal courts. The first is Brown v. ATF, filed in the U.S. District Court for the Eastern District of Missouri. The plaintiffs include the Second Amendment Foundation itself, the American Suppressor Association, the National Rifle Association, the Firearms Policy Coalition, a Missouri gun retailer called Prime Protection, STL Tactical Boutique, and 2 private citizens. The second is Jensen v. ATF, filed in the U.S. District Court for the Northern District of Texas. That case has been consolidated with a related challenge, Silencer Shop Foundation v. ATF, and involves the Citizens Committee for the Right to Keep and Bear Arms, the Firearms Policy Coalition Action Foundation, the Texas State Rifle Association, a federally licensed dealer, and several individual plaintiffs. Both sides in that case have already filed competing motions for summary judgment. An motion hearing was held before the presiding judge earlier this month. meaning Jensen is arguably the furthest along procedurally of the three cases, with a ruling potentially coming sooner rather than later. The third is Roberts versus ATF, filed in the U.S. District Court for the Eastern District of Kentucky. Its plaintiffs include Jews for the Preservation of Firearms Ownership, the Center for Human Liberty, the American Suppressor Association Foundation, the Buckeye Firearms Association, an ordnance manufacturer, and two private citizens. Buckeye Firearms Association, which is primarily known for advocacy work in Ohio, joined this particular suit, specifically because its members include suppressor and short-barreled rifle owners who wanted direct standing in a federal registration challenge rather than simply filing supportive briefs from the sidelines. 3 different courts, 3 different sets of plaintiffs, but all making a version of the same argument. Without a tax, the National Firearms Act's registration scheme for these items has no constitutional leg left to stand on. This week's filings lean on 3 Supreme Court decisions handed down over the past several weeks, and each one plays a different role in the argument. The first is United States versus Hamani, decided unanimously by the court on June 18th. That case involved a Texas man prosecuted for owning a gun while using marijuana. The court ruled that the government cannot automatically strip someone of their Second Amendment rights just by showing they use a controlled substance. It has to show that person actually poses a danger. The ruling was narrow and didn't touch suppressors or short-barreled rifles directly, but SAF's briefs point to its core holding. The government can't lean on a blanket, status-based restriction without individualized proof of danger, and the National Firearms Act's registration scheme for suppressors and short-barreled rifles is exactly that kind of blanket restriction. The second is Wolford versus Lopez, decided 6-3 on June 25th. That case struck down a Hawaii law that barred concealed carry permit holders from bringing firearms onto private property open to the public without the owner's express permission. The court's opinion reinforced its text and history framework from the earlier Bruin decision, making clear that once conduct falls within the plain text of the Second Amendment, the government carries the burden of proving a restriction fits the nation's historical tradition, and that courts owe the government no special deference in that analysis. SAF's briefs cite Wolford for that same evidentiary structure, arguing the government will struggle to find a historical twin for treating suppressors and short-barreled rifles as items requiring lifetime federal registration. The third is Landor versus Louisiana Department of Corrections and Public Safety, decided 6-3 on June 23rd. This one is worth explaining carefully, because it isn't a gun case at all. It's a religious liberty case involving a Rastafarian former inmate who sued prison officials after they forcibly shaved his head. The court ruled that officials couldn't be sued personally under the law in question, because Congress's power under the Constitution's spending clause is limited to whatever conditions the parties involved actually agreed to. Congress cannot stretch its enumerated powers into an open-ended authority to regulate people who never consented to those conditions. SAF isn't arguing that Landor is about guns. It's using the ruling's underlying principle, that Congress cannot rely on one constitutional power, like the power to spend or the power to tax, as a backdoor to regulatory authority it doesn't otherwise have. Applied to the NFA, the argument goes like this. If the taxing power was Congress's only justification for regulating suppressors and short-barreled rifles, and the tax is now gone, the registration scheme built on top of that tax cannot survive on its own. Put together, the 3 rulings give SAF's lawyers a 2-part argument. Landor's reasoning suggests Congress no longer has a taxing power basis for the registry now that the tax itself is zero. And Hamani and Wolford suggest that even if courts look past the taxing power problem, the underlying restriction still has to survive the Second Amendment's text and history test on its own, a test the government has increasingly struggled to pass this term. SAF's Senior Director of Legal Operations, Bill Sack, said the recent rulings gave the organization a clearer way to explain to the courts why the remaining registration scheme lacks constitutional authority. SAF founder and executive vice president Alan Gottlieb said the organization considers the rulings binding precedent that strengthens its position in all 3 cases. Gun control advocates are expected to push back hard if any of these 3 cases reaches a favorable ruling. Their likely argument mirrors what's been raised in other recent Second Amendment litigation, that suppressors and short-barreled rifles were singled out by Congress in 1934. Precisely because lawmakers considered them unusually dangerous, easily concealed, and disproportionately linked to criminal use compared to standard rifles and handguns, and that removing federal registration would strip law enforcement of a tool used to track those specific weapons after they're recovered at crime scenes. The government's defense in all three cases is expected to lean on some version of that public safety rationale, separate from the taxing power argument that SAF says has already collapsed. The Department of Justice, representing the ATF as defendant in these cases, has not yet filed its own responses to the July 14th supplemental briefs, though it will need to address the taxing power argument directly, since Landor's reasoning about congressional power leaves relatively little room to argue around. So what's actually at stake if any of these three lawsuits succeeds? The registration requirement for suppressors and short-barreled rifles would fall. That means no more $200 tax stamp process to navigate, even though the tax itself is already zero. The paperwork and registration obligation remain until a court strikes them down. It means no more 9 to 12-month wait times for ATF approval before taking possession of a suppressor or short-barreled rifle. And it means removing suppressors and short-barreled rifles from the National Firearms Act registry altogether, treating them the same as any other firearm under federal law. The path from here runs through three separate federal district courts before it goes anywhere near the Supreme Court. If one of the three cases wins at the district level and survives an appeal, or if different circuit courts end up disagreeing with each other, that kind of circuit split is exactly the scenario the Supreme Court typically uses to decide whether to take up a case. And this Supreme Court has already shown an appetite for expanding Second Amendment protections this term, having granted certiorari in the pending AR-15 cases, Viramontes v. Cook County and Grant v. Higgins, while also ruling in favor of gun rights in Hemani and Wolford. None of the three NFA cases has reached a final decision yet. Each is still moving through summary judgment briefing at the district court level, and a ruling in any one of them could come at any point in the months ahead. But for the first time since the National Firearms Act was written in 1934, gun rights lawyers now have a Supreme Court term's worth of rulings that directly undercut both of the law's original legal foundations, the tax that funded it, and the deference courts used to give it. Whether that's enough to bring down a 92-year-old registration scheme is now a question for three district court judges to answer first.